It's indeed my privilege to host today's webinar. It's a matter of great pride for me to host this 102nd webinar. And this has been possible because of your love and affection and your confidence reposed in us. Friends, as you all know, today is the first webinar of the month, and we dedicate this first webinar to cover, discuss, and deliberate the regulatory and legal changes which have taken place in company, securities, and insolvency law. This gives us an opportunity to keep ourselves updated in case we have missed out on any latest development. This is one forum where we can catch up with all the changes, and also gives an opportunity to us to clarify if there are any doubts or confusions from the experts. We have a very elite panel of speakers. We have Ms. Anjali Agarwal, Partner and Head, Capital Market Services, Corporate Professionals. We have with us Mr. Ankit Singhi, Master in Company Law, Partner and Head, Corporate Affairs and Compliance, Corporate Professionals. Mr. Manoj Kumar, Partner and Head, M&A and Transactions, Corporate Professionals. The Storehouse of Knowledge. Ms. Mohini Vashne, Partner and Head, ESOPs and Insider Law. She will cover the changes in insider law today. Ms. Ruchika Sharma is Associate Partner, Corporate Professionals. Friends, there are quite a few updates in company law, securities laws. What we propose to do is to start with company law, followed by updates through SEBI, changes in SEBI regulations or the clarifications issued by SEBI. And we will take up one by one the updates. May I now invite Mr. Ankit Singhi to start with updates in company law. Mr. Ankit Singhi, please.
Thank you, sir, and good evening to everyone. And it's our privilege to being as a panelist where you are hosting the webinar. So I'll start with the session with the updates on the corporate law, that's Companies Act. So is my screen visible?
Yes.
Yes. Okay. So like previous month, in terms of Companies Act, it was not such as eventful as our other securities law, where there are a lot of changes every month, new things are coming. But there were some changes in the Companies Act, which we will be discussing with you today. So on 4th November of last month, the Ministry of Finance, Department of Department of Economic Affairs issued a exemption notification for IFSCs from certain provisions of the Companies Act with respect to substitution of word SEBI with IFSC authority wherever it appears in the Companies Act. So as we are all aware that International Financial Service Center is another name as Gift City. There are separate rules, regulations with respect to a lot of things, and there are a lot of exemptions in the Companies Act. And even the regulations of IFSC regulatory authority, there are separate regulations for issue and transfer of securities. So in order to ensure that there is a sync between IFSC in terms of the regulations they have issued for regulating the issuance of and transfer of securities, Ministry of Corporate Affairs has accordingly amended the word SEBI and removed it from wherever sections wherever it's appearing, so far as they relate to any financial product or financial services offered by or financial institutions in an IFSC, and all wherever the SEBI was appearing, IFSC authority has been substituted in across all the sections. So generally, these exemption notification was issued by companies, Ministry of Corporate Affairs under Section 462, I believe. But this time, this was issued by Department of Economic Affairs, Ministry of Finance, and even Section 24, with empowers SEBI to deal with matters with respect to issue and transfer of securities in case of companies which are listed or which proposes to be listed. That section has also been substituted altogether, and with similar provisions are there, but SEBI is replaced by FSC authority. So FSC authority will now regulate all transfer or issue of securities so far as they are being done by an entity in a IFSC, that is International Financial Service Center. So it's a whole list of sections wherever the word SEBI is appearing under the Companies Act and relevant to the context. The circular outlines that SEBI will be replaced by FSC authority in all these places. So it's a long list of provisions wherever SEBI is there. Coming together to the next amendment is with respect to the valuation rules. There was an amendment in the valuation rules issued under Section 247 of the Companies Act, where there is a provision that a partnership firm or a company is eligible to be registered as a registered valuer. Now, one of the eligibility condition they have added is that these entities should also be member of one registered valuer organization. So there are a lot of registered valuer organizations who are authorized by IBBI. And so if a partnership firm or a company wants to register as a registered valuer, then it should also be a member of one of the registered valuer organization. And at one point of time, it should not have more than membership of more than one RVO at a particular point of time. So you cannot be a member of two RVOs at the same point of time. With respect to existing partnerships or companies which are registered as valuer, there is a transition period that has been provided. That is within 6 months from 21st November 2022, within which you have to become a member of one of the RVOs that are authorized by the IBBI. Similarly, there are new introduction in terms of Rule 7A, Rule 14A, where any change in terms of the registered valuer personal details, changes in the details of partners, directors in case of company partnership, changes in details of partnership firm or MOA, so far as it relates or has an impact on the ability of the registered valuer to work as a registered valuer. All these will required to be now intimated to IBBI on payment of prescribed fees, which has been prescribed in the schedule to the rules. Similarly, RVOs are also required to intimate changes in the governing council and other required changes to IBBI on the lines of registered valuer. So both registered valuer and registered valuer organizations are required to intimate changes to IBBI within the prescribed, no times as such is prescribed, but there is a fee schedule that is prescribed. And moving ahead, so Rule 3 of the valuation rules outlines a list of eligibilities one should have in order to be registered as a registered valuer, like postgraduate diploma, postgraduate degree, then there are bachelor's or equivalent courses, then there are professional courses like CA, CS, ICWA. So, and there is a schedule 6 that is provided under the rules, which outlines an additional list of professional qualifications one may have in order to be registered as a registered valuer. So there is just a clarification has been added to that schedule, whereby it has been provided that in addition to these qualifications which have been mentioned in therein, so far as it relates to an eligibility for the purpose of registering as an registered valuer in the asset class of plant and machinery or land and building, the similar nomenclature as used by All India Institute of Technical Education in this notification with respect to engineering and technology qualifications that are provided therein, they will also be treated on same level in terms of the qualifications that have been mentioned in the Schedule 6. So these courses, if you have done these courses in these areas of engineering technology as mentioned in this notification, that will make you eligible for applying for registration as a registered valuer in these classes. So these are the key changes with respect to Companies Act. There was a small case with respect to struck-off companies, where income tax authorities have issued a notice to an entity which was struck off under the Companies Act, and the petitioner filed an application that the notice is not maintainable. But the entity against which the notice was sent by the income tax authorities, or later on it was revived by the tribunal under section 252. And so the Delhi High Court said that since the company has been revived, and so the revival will be deemed came into effect from the day it was struck off. So if it is revived from that particular day, then the notices were issued to the company even while it was struck off, it was not in existence, will also be revived along with the revival of the company. So this is an important judgment. A lot of income tax authorities are filing cases for revival of a lot of companies where there are certain kind of assessment which are pending. So these will help courts and tribunals in taking better judgment. So that's all from me. I think now Anjali will take care of the updates in securities law starting from LODR. Thank you.
Thank you very much, Ankit. Thank you very much. And as rightly stated by you, this exemption notification was issued by the Ministry of Finance, Department of Economic Affairs, and not exercising the powers under the Companies Act, but exercising the powers vested to it under the IFSC Act. So it is through that act, the powers vested in that act, that exemption notification has been issued. Now, may I invite Anjali Agarwal to please carry forward the discussion on LODR, and then she should request her to also cover the notification of private placement.
Thank you, sir. Good afternoon, everybody. As Ankit also said, it's our pleasure to be a part of this journey wherein 102 webinars have been conducted by corporate professionals. And now taking you over to the amendments which have taken place during last month in the LOD, in the securities laws regime. Shivam? So the most of the amendments that have been promulgated are with regard to the listing regulations. All these amendments were discussed by SEBI at their board meeting of September 2022. Now, all these amendments have been given effect with effect from 14th of November 22. First of all, the very important amendment is with regard to appointment and removal of independent directors. Under the extant law, the requirement was that the appointment or removal is to be approved by way of a special resolution. However, SEBI observed that in a few cases, SR was not passed. The approvals was obtained only by way of ordinary resolutions. So now it has been mandated that in case the approval is obtained by way of an ordinary resolution, simultaneously it has to be ensured that the majority of public shareholders should approve the resolution. Then the appointment or removal can be given effect to. That is, majority of minority rule is has been introduced. Shivam? A very important amendment which has come simultaneously in the ICDR regulations and also in the LODR regulations is with regard to appointment of a monitoring agency. Under the extant law, the requirement of appointing a monitoring agency is only with respect to public issues or rights issues of an issue size of more than 100 crores. But now, along with public issues and rights issues, even the preferential allotments and QIBs have been covered within this category. And for a preferential issue of more than 100 crores or a QIP of more than 100 crores, a monitoring agency will have to be appointed, which will oversee the utilization of the issue proceeds and give a report to the audit committee and to the board to be published simultaneously with the results publication as well. So this is an important provision from the point that the maximum number of further issues that any company does are through the preferential issue route. So whenever it does a preferential issue of more than 100 crores, it has to appoint a monitoring agency. Simultaneously, we have to keep in mind that earlier monitoring agencies could have been any of the banks. But now the monitoring agency can only be a credit rating agency which is registered with SEBI. So presently there are 7 credit rating agencies registered with SEBI. Any of those can be appointed as the monitoring agency. There have been some important amendments with regard to debt listed companies. It was being observed by SEBI that debt listed companies, there have been some lapses or the other when it comes to the compliances of a debt listed company. Wherein equity is listed, those companies were comparatively having more professionals on their board, and though they were able to comply in a better way, but debt listed companies, some few of the provisions were also not very clear. Now it has been mandated that the financial results shall be under the existing law. The requirement was financial results are to be submitted within 45 days from the end of each quarter, except the last quarter. The words were except the last quarter. Now for the last quarter, again, it has been mandated that within 60 days from the end of the quarter. So just like in equity regulations of LODR, the way we have to give the results within 60 days of the end of the financial year, likewise, here also within 60 days of the end of the last quarter, we have to give the results. This again has become effective from 14th of November 22. In case of companies wherein audits are done by the Controller and Auditor General of India, in Regulation 52, it has been amended that the issuers which are required to have the audit done by CAG have to submit the unaudited financial results plus the limited review report issued by the CAG or the auditor appointed by CAG or any PCA, plus the financial results audited by CAG. This is an important amendment in respect of most of the PSUs. With regard to utilization of proceeds of debt issue, under the extant law, the requirement is within 45 days of the end of the quarter, the utilization of issue proceeds is needed to be submitted. But some of the companies were giving their results, say within 30 days, but they were giving this statement within 45 days. So now it has been mandated that this statement is also needed to be given along with the quarterly financial results of the company. So if you're giving the results within 30 days, simultaneously you have to give the issue proceeds detail as well. With regard to line items to be submitted along with results, 2 of the items have been done away with. The rest of all the items remain the same, but 2 items, which is the operating margin and the sector specific ratios, are not required to be given in the line items along with the results. Rest all have to be followed the way the companies used to follow it prior to 14th November. This is one of the very important provisions, that in case a debt listed company enters into a scheme of arrangement, under the erstwhile provisions, there was no clarity whether a debt listed company is required to obtain a NOC from the exchanges with regard to the scheme. For equity listed company, Regulation 37 is very clear that you have to obtain the stock exchanges as well as SEBI permission. But for a debt listed company, this provision was not clear. So Regulation 59A and 94A have been inserted, wherein it has been mandated that before filing any draft scheme of arrangement, stock exchanges permission is needed to be obtained when any of the non-convertible securities are listed with the exchanges. Again, with regard to debt listed companies, it was observed that there were amounts which were lying in the escrow account for more than 7 years, and there was no clarity as to what should be the modus operandi for that. Now it has been clearly mandated that for any amount, unclaimed amounts lying in the escrow account for more than 7 years pertaining to non-convertible securities issued by such company, the same shall be transferred to IEPF account created by SEBI. This again has become effective from 14th of November. Okay, there has been a reduction in timeline to list the debt securities on private placement basis. SEBI has reduced the timeline for listing of debt securities issued on private placement basis to 3 days. Currently, this timeline is 4 days, and this is the idea behind this is to expedite the listing and trading of the securities by the investors. An ebook platform is to be availed by the companies. For any issue size of more than 50 crores, availing the ebook platform is mandatory. But for anything less than 50 crores, it is the choice of the company whether to avail it or not. This circular will become effective from 1st January 2023. This is a new circular which has been issued by SEBI on providing the framework for online bond platform providers. It was being observed that in the recent times there has been a good mushrooming of online platforms which were providing for bond trading, but they were not registered. So as a result, and simultaneously, it's not just that the service providers were increasing, even the investors that were registered with these platforms had increased manyfold. So as a result of which, there was no surety as to the security or as to the benefits that will be given to those investors, to those people who were using those platforms. So SEBI has come out with this registration mechanism for online bond platform providers, wherein only a stock broker can be registered as a online bond platform provider. And it has been mandated that before registration, the platform provider cannot offer any products or securities on the platform except the listed debt securities or debt securities proposed to be listed through the public offering. This circular is a investor friendly circular, which will help a lot of the people who were investing through these online platforms, not knowing whether the platform will sustain, will be able to continue in the times to come or not. This circular will help in a big way. Monitoring agency I've already discussed. For any preferential issue or QIP of more than 100 crores, a monitoring agency is needed to be appointed. This circular, this amendment in the ICDR regulations has already become effective with effect from 21st of November 22. So these were the amendments which were there pertaining to the listing regulations or ICDR regulations and the debt listed securities. Now over to Mohini to take up the insider trading regulations amendments. So you are muted. So you are muted.
Anjali, I just want to know one thing. You have dealt with an amendment with regard to appointment and removal of independent director. Now, what do we say in the notice for the general meeting? Because we say to pass the following resolution as a special resolution with or without modification. How do we go about it? What is your suggestion?
It will be mentioned special resolution only, but the scrutinizer, while calculating the voting, will have to, and in the explanatory statement, somewhere we'll have to give the statement that in case this resolution is not passed as a special resolution, the ordinary resolution plus majority of minority will be seen by the scrutinizer.
Thank you very much, because this is important. That in the notice we will say to pass the resolution as special resolution.
Yeah.
Explanatory statement we will say that where the special resolution has not been passed, but the votes cast in favor of the resolution exceed the votes against the resolution, and the majority of the public shareholders have voted for the resolutions, the resolution will be considered as passed. Yeah. Thank you very much, Anjali. Thank you for clarifying this. Now, may I invite Mohini to take us through very major amendments have been made, because PIT has been made applicable to the mutual funds. So the mutual funds have been brought under the ambit of insider trading law. So please take us through these changes. Mohini, over to you, Mohini, please.
Yes, thank you everyone, and good evening. So earlier we are aware of that in the PIT, that means insider trading norms, listed companies, either they are listed through their equity shares or they are listed through their debt. In both of these cases, the PIT regulations are applicable. And in the definition itself, it has been very clearly written that it's except the mutual funds. So in that case now, because the people who are dealing in the mutual funds, that means the people who are working in the AMC, trustees, as a director, as the fund managers, all these are aware of the investments they have made, but all are aware of the portfolio companies and the various other integrities which are involved in the day-to-day functioning of the mutual fund schemes. So to take that, dealing in the mutual funds and the trading in the mutual funds in their ambit as the insider trading. So the PIT, in the PIT, a new chapter has been added for to handle the dealing in the mutual funds by the persons who are the insiders to that information, which affect the dealing in the or the pricing of the this mutual funds. So now I take you through this amendment in a very brief and in a crisp manner. So the first is that earlier, as I covered, that earlier in the securities definition under the PIT law, it has been written that it is except for the units of mutual fund. That means trading except for the mutual funds is there in the PIT, but to make the trading in the mutual fund as a part of the insider trading norms, so they have deleted that word. And now, as per now, the mutual fund dealing is also be a part and covered by the insider trading. Next. So now, who is insider for the mutual fund? So in the mutual fund context, the insiders are the persons who are connected persons. The same definition and are there in the connected person case. And also they have said that in any person who is in possession or having access to UPSI pertaining to a scheme. Scheme means a scheme of mutual fund launch as per the SEBI mutual fund regulations. So that means for every scheme will be treated as a separate security in the mutual fund case. And also not only the person who has a possession of UPSI, also any other person who has received that information because of any legitimate purpose from the person who possesses it, that person also comes within the ambit of insider in the mutual fund case. So next. So now in this, again, similar like in the equity listed company, there is a concept of designated persons. So the same concept is here in the designated persons as well. So who all people are covered under the designated persons here? So we start with the compliance officer, head of all divisions, department, and all employees of the fund operation department. Then fund managers, dealers, research analysts. Chief investment officer, chief risk officer, chief operation officer, chief information security officer, then directors of AMC or trustee, and head of AMC like CEO, MD, president, or by any other name, they have the head. So all these people are now being covered by under the designated persons category in with respect to this mutual fund. And along with this list can be increased to any employee who is working under this mutual funds organization, which can be done by the board of directors of the AMC in consultation with the compliance officer. So similar, it's like an equity listed company. The ambit can be increased anytime. Yeah, next. Now, similarly, as a concept, because entire insider trading is based on the UPSI. So in this also there is a UPSI in the mutual fund as well. So here the for the test for proving any information to be an UPSI. Here the information has to pass these 3 tests. Like first, it is pertaining to a scheme of a mutual fund. Then the information is not generally available to the public. And this information which the person has materially impact the NAV or materially affect the interest of share unit holder in case it becomes public. So similar, these three tests the information has to pass to categorize as a UPSI. There are various examples, and the list of events have been also given in this now in this amendment, that what all to be treated as a UPSI in case of a mutual fund scheme. So like the change in the accounting policy through which these mutual funds are being operated. Then material change in the valuation of any asset or a class of assets in the mutual fund. And that with respect to any scheme only. Restrictions on redemptions or winding up of that scheme. Creation of segregated portfolio. Triggering of swing pricing framework. Material change in the liquidity position of that mutual fund scheme, and default in the underlying security, which is material to the concerned mutual fund scheme. So this is only the list, which the events which they have mentioned. But other than that, if any other information also pass these three tests, it will be categorized as a UPSI in this mutual fund case. Yeah, next. So now similar that now when the person has an UPSI, so what all restrictions have been imposed with respect to this UPSI. So same, that the UPSI share should be shared only on a need to know basis. That means it's for the legitimate purpose, it's for the performance of duties and discharge of some legal obligations. And like in the listed equity company, the company has to prepare, a board of directors to prepare a policy for the legitimate purpose. The same policy now the mutual fund houses has to make for sharing the information in the company. Now, same like when the person has an UPSI of a scheme and they want to share that information with someone else, definitely it has to pass the legitimate purpose test. But the other things which the person has to obtain from the next receiver of the information is that same confidentiality agreement need to be signed, NDA need to be signed with the person. The person has to record, who is sending the information has to record in the structured digital database as applicable in the present listed companies case. In the same structured digital database model, they have to update the nature of the UPSI, name of the person with whom that UPSI has been shared, whether inside or outside, same concept, and the permanent account number or any other identifier of the receiver. So same three information has to be captured in the structured digital database. Next. That means now in the like the other listed companies have now maintaining the structured digital database. Same, all the mutual fund houses now have to maintain a structured digital database for recording the transmission of information with respect to the mutual fund schemes operating in their company. So what in the structured digital database the person has to do? So the first is the responsibility to comply is definitely the board of directors. Responsibility to maintain and prepare is all designated persons handling UPSI. Hosting of database shall not be outsourced. That means internally in-house servers are there. Basic requirement of the law is same, time stamping and audit trails, and maintenance is same, 8 years minimum the records need to be maintained. So the structured digital database is the now to be maintained by every mutual fund house. Next slide. So now what the trading related restrictions in this case are. Shivam, next please, next slide. So same trading restriction. So in the this mutual fund, instead of trading window period, they have introduced a new word like a closer period. So it's the same like the trading window concept. But in the closer period, there is no mandatory closer period has been defined. Like in the listed equity shares, they have made that like every quarter end, there is a mandatory trading window closer. So there is no mandatory trading closer period, but the closer periods are there. And during that same concept, during the closer period, the trading in the mutual fund cannot be done by the designated person. And in case there is no closure period, they are free to deal in the scheme or those mutual funds. Now, in case now when the closure period is there, the compliance officer shall determine the closure period time to time for the designated person based upon the UPSI which they possess. And they will not be able to trade in those schemes particularly. But there are for certain transactions which are excluded from this closure period restrictions. So first is, again, statutory or regulatory obligations are there and they need to trade in that mutual fund. They can do off-market interstate transfer between insiders. They can do similar, the systematic transactions like SIP. They are allowed to continue with those SIP. Only the condition is that for that SIP, they have taken the approval of the compliance officer at least 2 months prior to the starting of this SIP. So in that case, they are allowed that they can they can start their, they pay their amount during the closure period as well. And similarly, they are allowed to pledge the units of a bona fide purpose. So, but all these are subject to the pre-clearance in case they want to trade in that mutual fund units. Yeah, next. So when the closure period is not there and they are free to trade and deal in the mutual fund units, they have to go and obtain the pre-clearance of trade. For the pre-clearance of trade, the compliance officer can define the value that up to what value they are free to without pre-clearance, and for which after which value the person has to take the pre-clearance from the compliance officer. So in this, because there are different kinds of mutual fund schemes are there, so the separate thresholds can be put in for the systematic transactions and for the lump sum payments. So for both the categories, different kind of pre-clearance limits can be put in. This again, same, the pre-clearance is valid for 7 business days within which that pre-clearance need to be executed. Here, the concept of business days has been introduced instead of the trading days, and because otherwise in the PIT it's a trading day and working days concept. But now they're here in the mutual fund, they have introduced the concept of business days. Now in this, pre-clearance is required, and the 7 days it's a validity. But so they have given some exemptions that in case the pre-clearance is not required in these kinds of trade, like if they are investing in index funds, if they are investing in the exchange traded funds, and if they are investing in the overnight schemes. So in these all cases, there is no requirement of obtaining any pre-clearance. Next. Other miscellaneous provisions added and introduced is like a contra trade, same. So here the contra trade means, again, the opposite transactions cannot be done, that if you have purchased, you can't sell it off. But here in this, in any way, it should be only 2 months. So that means in this listed equity shares and debt listed securities, PIT has prescribed a period of 6 months for not entering into contra. Here, this period is 2 months only. Here, the exception of contra trade is only the overnight scheme. So in the overnight scheme, this contra trade restrictions are not applicable. Then connected person definition is there, wherein again, like any person who leaves the organization in the listed companies, there the person remain connected for a period of 6 months. Here that period has been reduced, and that will be again a 2 months period only. Again, the systematic transaction has also been defined in this case. So in the systematic transactions, which we have earlier covered, that there are certain exemptions for it. So the systematic transactions have been defined as the units of mutual fund where the transactions are automatically triggered for execution on a periodic basis as instructed by the investor, including investment plans, transfer plans, and systematic withdrawal plans. So all these 3 schemes are being covered under the systematic transactions. Next. Now, what all the disclosures are being required by the designated persons now? So designated person has to give a disclosure with respect to all the transactions done by themselves and their immediate relatives in the units of its own mutual fund above the threshold limit. Here, the threshold limit has not been prescribed. The threshold limit will be prescribed by the board of directors here, and beyond which, if they are trading, then they have to give the disclosure to the their organization, and the AMC has to give the disclosure to the stock exchange. So this, again, a 2 business day concept has been introduced. However, with respect to the systematic transactions through any mutual fund scheme, DPs may report the same only at the time of making the first installment. So regularly, if they are making a 2,000, 5,000, 10,000, whatever the payment schemes are, so they not report every time. They have to take at the initiation of that mutual fund SIP plan, and then again, every month they need not to. There are also certain transactions for no disclosures are required, like subscription or investment in mutual fund pursuant to the mandatory requirement by the KMPs as per the norms of the SEBI under the mutual funds there, because the the KMPs working in the AMCs and the fund managers, like, so they have to mandatorily invest in those schemes which they are managing. So for that, if they are investing, so for that no disclosures are required by them. Also, similarly, if they are investing in trade overnight scheme or index fund or exchange traded fund, in these three cases also, they are not required to give any disclosures if they are trading in that. So no transaction-based disclosures in this investment as per the mandatory requirement, overnight scheme, index fund, and exchange traded fund. But in case other than this, if they are trading, then beyond a value, they need to disclose it to their AMC within 2 business days. Sorry. Next slide, please. So when they give the disclosure, the compliance officer of the AMC has to give the disclosure and inform to the stock exchange within 2 business days again. As an asset management company, also the company has an obligation to give a disclosure. So in this, they have to give the details and disclose the details of the holding in the units of its mutual fund scheme on an aggregate basis held by the designated persons of AMC, trustees, and their immediate relatives. And that is to be given on first on such date as specified by the SEBI, and then on a quarterly basis thereafter to the stock exchange or any other mode which the board SEBI will come out. So in this manner, asset management company has to disclose on a periodic basis about their interest and their holding in their mutual funds units. Next. Other disclosures which the designated person has to give, that is with respect to their holding in the units of the mutual fund. This is with respect to the information being a designated person. So they have to give the information of their immediate relatives. The same concept is there as of an immediate relative, that either they are financially dependent or they are taking their help in taking the financing decisions of their. So it's immediate relative information they need to give. Similar, the persons with whom they have the material financial relationship, that means 25% of their annual income they have given to someone. So that information they need to give. Again, the phone and the mobile number, educational institutions from where the designated person has graduated, and the names of their past employers. So this information also being implemented for now the designated persons of the mutual fund, AMCs of mutual fund organizations as well. And this same, it's a mutual fund on annual basis. They have to give this, and again, whenever there is a change in information, they have to make their organization informed immediately. Next. Other compliances which is to be done by the company, mutual fund organizations. So the first is they need to maintain their code of conduct. The code of conduct, the responsibilities on the board of directors. Then the purpose is definitely to regulate, monitor, and report the dealing in the mutual funds by the designated person and the immediate relative of the designated person. In this code of conduct, they have to specify all the things like the pre-clearance limit, the thresholds, the reporting requirement. All these things need to be covered under the code of conduct only. Minimum standards that the company should frame its code of conduct as per the new schedule B1, which has been introduced. Without diluting the provision of these regulations, they can frame their code of conduct as they want to. Then administration is to be done by the compliance officer in the organization. Next. One thing to add, the same kind of code of conduct need to be framed by those fiduciaries who are dealing in the mutual fund. So same kind of code they need to maintain as well at their end. Then the mutual fund organization has to maintain their internal control. So they have to create a policy of maintaining the internal control for prevention of insider trading. And this is the duty of the and the responsibilities on the CEO or MD of an AMC, which they need to. And purpose is to again prevent an insider trading and shall include the points as given under this regulation. That means transmission of information also they have to take care of. And review of the compliances, again here also the audit committee has been interested on this that they will review the compliances of this provision once in a financial year, and whatever, and they can also check it on a periodical basis as well. And same kind of internal controls has to be framed by the other parties who are working in a fiduciary capacity, dealing in the mutual funds. Yeah, next. Other policies which every AMC has to float is like the AMC has to make the policy for the policy for inquiry in case of leak of UPSI of these schemes in the organization. AMC has to make a policy for the like a whistleblower policy in case anyone wants to report for the leak of the UPSI. Yes, next. So this is all about the mutual fund schemes. Yeah, thank you.
Thank you very much, Mohini. This is a very major change for mutual funds. Mohini, as an expert in insider trading, what are your quick advice to the mutual funds? How they should go about it, and what should they do?
Sir, immediate is definitely once these regulations have come into force, so they have to first have to give their basic disclosures. So all designated person have to start giving their disclosures. They have to give the disclosure with respect to their relatives, their holdings, and the AMC also should start gathering this information. Next immediate step the companies has to take is to implement their structured digital database, because now the transfer of information between any two persons need to be recorded. The third thing is that they immediately have to sign the NDAs with the persons who are in fiduciary nature and are dealing with their mutual funds. So they have to obtain their PAN numbers and all, so that they be able to record and comply with the SGD requirement. And then they have to prepare the code of conduct, and they should be strong. They should strongly formulate the their internal control policy, because it's not the overall they can implement, because for every scheme they have to monitor. So it's difficult. It's in the listed companies, they have only one equity to deal with. Here they have a multiple mutual fund schemes. So for every mutual fund scheme, they have to deal it differently. So that's the suggestions from my side.
What are your advice? How should they sensitize their boards, all the employees, and all connected persons?
So that need to be start immediately. Reason being because it's now in force, and because the people are not aware of that they need to disclose something. They can't trade. There is a closure period concept now introduced. They might be in the possession of UPSI. So yes, definitely starting of the familiarization programs should be there in the mutual fund. The compliance officer has to take this responsibility, and they have to start. They can send the mailers. They can start giving the post. They prepare the posters for that. And if they want, any person like we are also be able to guide them that how they can familiarize their designated persons in this case.
Thank you very much, Mohini, for
taking. You, sir. Thank you everyone.
Development in the field of insider trading. I think much needed a step taken by SEBI. Now, may I invite Mr. Manoj Kumar, our stalwart in securities laws and takeovers, to take us through the amendment in the takeover law.
Thank you, sir. Good evening, everyone. So there is no many changes in the takeover law. There is one update that SEBI has created a new committee to review the entire takeover regulations and give suggestions for amendment as may be required, because it was last amended in 2015. It is already Achyutan committee has given the recommended. Based on that, this present takeover regulation is there. So it is being reviewed thoroughly, and there may be various amendments. However, recently they have made two amendments which are very small but very important. One is with respect to PSUs, government companies. Government, as we all know that government is looking at disinvestment of many of the government companies, PSUs, which are listed. And to simplify or ease the process of disinvestment, this first amendment has been introduced in the law, which is providing that the valuation for the purpose of takeover open offer, in case of disinvestment of a public sector undertaking. The price value market price method, which is required to be one of the criteria for determining the public offer price, that is volume weighted average price of 60 trading days, would be ignored in this case. So whatever the negotiated price or bid price determined for the purpose of transfer of control by government to any public private sector entity or person shall be the offer price for the purpose of takeover also. The market price may or may not be similar or equal to that price, and hence that would not be considered for the purpose of this disinvestment process. So this is one amendment. Another amendment, I think, is with respect to there is a situation where a takeover offer has been given by any company, any person, for any acquisition of a listed company, and that during that period there is a time period of 25 working days from the date of DPS, detailed public statement. After that, if the person puts 100% cash into the escrow for the purpose of the for the value equal to the value of the offer, which he has to give mandatorily, or it has to give mandatorily, then only they can take control over the company. Otherwise, they have to wait till the open offer process completes and the shares tendered in the takeover offer is acquired by the acquirer. So in that period may be sometime, generally 4 months, and it may go up to some longer period also in case there is some litigation or something. So to ease that, to make the life simpler for the acquirers, now they are saying, in place of putting the cash into the escrow, they may continue to they may provide bank guarantee of the value of 100%, and that bank guarantee has to be from scheduled commercial bank as in general case, but they are putting restriction that this bank guarantee should be unconditional, irrevocable, and it has to be given by any one of the bank which is approved by RBI. Also, they have put an explanation that the bank guarantee will come from any bank which is graded for at least AAA grade for any of the loan they have in their book. So that kind of banks, there are many scheduled commercial banks which can provide bank guarantee for takeover offer in normal circumstances. But for this purpose, it has to be from a bank which is listed by RBI, approved by RBI, and have AAA rating. If that is happening, then the process of taking control of the listed company can be expedited. So these are the two amendments, and I think these are to simplify the process. There are many companies, PSUs, which is going for disinvestment, and that will be faster. Similarly, there are many cases where cash is stuck without any interest-bearing instrument, so that may be replaced with the bank guarantee, and that would help the acquirers to take control of a listed company faster way. These are the two major amendments and two amendment in the takeover regulation. Rest of the amendment would come after the committee recommendation comes, and then they may put discussion paper for the public comment, and based on the suggestions or considering all the suggestions of the public at large, there may be drastic changes in the takeover regulations. So these are the two amendments. Besides this, I think just after me, I think Ruchika will deal with amendments in the ICDR regulation, SEBI issue of capital and disclosure regulations, where a new chapter has been inserted with respect to pre-filing of IPO documents, that is offered draft red herring prospectus. So I think this was also a long drawn demand of the industry, that pre-filing provision should be introduced, which is already available worldwide. This pre-filing would allow companies to file the offer document to SEBI without disclosing to public at large. And if it is in principle agreed, approved by SEBI, or comments are received by SEBI, then only it will be placed for public comment, and after that it will be the IPO can come. So I think detail would be discussed by Ruchika. So Ruchika, you may take it from here. Thank you.
Thank you very much, Manoj.
Thank you.
And,
Thank you, sir.
We all will be keenly looking forward to the discussion paper on takeover regulations.
Yes, yes,
After
yes.
the Achutan committee report, it has been quite a while. So
Yeah.
we all are keenly looking forward to it, and we will have a very detailed discussion on the discussion paper itself,
Yes.
because that will be a game changer.
Right.
I now invite Ms. Ruchika Sharma to take us through the changes in ICDR. Over to you, Ruchika.
Thank you, sir. Thank you, Agarwal sir. Thank you, Manoj sir, for giving the brief introduction about the changes which are suggested by SEBI in ICDR regulation. So we have seen since May 2020, SEBI is coming out with consultation papers or seeking comments from public, issuing various agenda for the board meetings and coming out with comments in the SEBI press releases, through which they wanted to introduce this pre-filing of DRHP in the IPO process. Now, coming to the amendment, let us first understand that what is the existing framework which is given under SEBI ICDR regulation. So, for any issuer company which wants to go for IPO or which wants to file IPO document with SEBI, they have to first file the offer document, which is DRHP with SEBI, which contains all the relevant information which is required to be mandatorily mentioned in the offer document as per SEBI ICDR regulations, which involves a lot of business information, which involves a lot of financial information, business risk information, and certain confidential information with respect to shareholders agreement, capital structure, pricing at which shares are acquired. All those informations forms part of DRHP. That DRHP is hosted on the website of SEBI, lead managers, stock exchanges for public comments for at least 21 days. So that information goes on public even without knowing that whether the issuer company will get the approval from SEBI, or whether the issuer company, even if they get the approval from SEBI, will proceed with the IPO or not. So that remains on public domain. SEBI seek comments from public, lead managers seek comments from public. On the basis of comments and on the basis of in principle approval from the stock exchanges, other regulatory authorities, various clarifications from the lead manager, SEBI issues its final observation letter on the DRHP, which then after receipt of SEBI's final observation letter, the issuer company has to update the DRHP with all the facts, financial information which are updated or which has to be updated for that step period, which has been lapsed due to receipt of SEBI approval and all the procedural approval requirements. In this process, from the date of filing of DRHP till approval of SEBI, till issuance of observation letter from SEBI, the issuer company and the lead manager do publicity and marketing for the IPOs, and that they can do irrespective of any limitation. They are allowed to do marketing. They are allowed to test the waters, whether they can get the right valuation, how the investors are valuing their company, whether they'll get the success in the IPO or not. That all practice they can follow in this process, in this duration. Once this final observation letter is received, then the issuer company has to file the RHP with ROC, and thereafter they can come out with the opening of issue period where the public will subscribe to the shares of that company. So that was the existing framework. That was the existing framework before 21st of November when the amendment came. Now, what the major concern and why this amendment of pre-filing has been introduced, the major concern which industry faced is that, which I mentioned briefly initially, that a lot of confidential information, a lot of sensitive information about the issuer company, which was unlisted, which was not generally available in public domain, it was made available through filing of DRHP. So that gave an apprehension to all the issuer companies, or maybe most of the issuer companies, that their competitors or their peers can get each and every short and brief details, confidential details about their business, their risk, their process of doing the business, their all the financial numbers which generally were not available on public domain. by filing this DRHP. So they raised this concern, and then thereafter SEBI started initiating this discussion. And since May, the primary market regulator, primary market advisory committee of SEBI analyzed and came out with this amendment. They have also specifically noted the past trend, wherein they have observed that in last 3 financial years, that is 18-19, 19-20, 20-21, out of the 129 DRHPs which were filed with SEBI, only 72 were the cases which, got approval and move ahead with the process of IPO. So almost 44% were the cases where they got the approval, but yes, they did not move ahead with the IPO process, maybe because they were not getting the right valuation, or it doesn't, the issuer companies did not felt right to came out with IPO at that particular point of time. But again, since the DRHP was made available to the public domain, the information, all the confidential information was there in the market, there with all the even any layman person can go on the website of SEBI or stock exchange and get the information about the DRHP file, about the business, about the financial information of the company, despite whether they are getting success, whether they are going ahead with the IPO or not. So that was the past trend, based upon which they came out with the amendment, and they introduced Chapter 2A, wherein they have given an alternate option for the issuer companies, that either they can file the DRHP under Chapter 2, the existing framework, or they can opt for Chapter 2A, where they can do the pre-filing of DRHP with SEBI. And once they test the waters, once they are through with the valuation parameters which they will get, or once they are clear with the SEBI's viewpoint that whether they are getting the approval or not, or there are any major legal challenges, they can then further go for dissemination of all the information in the UDRHP, that is updated draft red herring prospectus, in the public domain. So that is there in this Chapter 2, the amendment. So I briefly informed, and I briefly described the existing framework and the timelines. Now I'll just compare the timelines in the alternate framework. So in the existing framework, you file DRHP, that DRHP is disseminated on public domain for 21 days. On that post, for public to give comments, post receipt of public comments, and post receipt of in principle approval from stock exchanges and any other regulatory authority, and post receipt of clarifications from lead managers, SEBI issue its observation letter. Once the observation letter is issued, that is valid for 12 months from the date of issuance, and in this period of 12 months, SEBI can come out. In this period of 12 months, issuer companies can come out with the opening of issue, in which the public will subscribe for their shares. But in the alternate and new framework, the process is the issuer company will file the DRHP prior with SEBI, and that DRHP, pre-filed DRHP, will not be disseminated on public domain. SEBI will issue its observation letter on that DRHP, again after in consultation with the stock exchanges, any other regulatory authority, after taking clarifications from the lead managers. And once the observation is received from SEBI, thereafter the issuer company has to update the DRHP and file the updated UDRHP with SEBI, which will be disseminated on public domain, which will be disseminated for at least 21 days for public to issue its comment. Post receipt of public comments by the lead managers or by the SEBI, when compiled together, the updated UDRHP2 will be filed with SEBI along with the changes which they have suggested in their initial observation letter. And thereafter, the validity period for opening of the issue has also increased in this amendment. That is now, which was earlier for only 12 months with the issuer company, now is extended to 18 months from the receipt of SEBI's final observation. And in those while for that validity period, there is a proviso which states that you have to file the updated DRHP with SEBI within 16 months from the receipt of the final observation letter. So from earlier you were getting only 12 months time to open the issue. Now you're getting 18 months time to open the issue. Some of the significant changes which have come up in this chapter, which has come up because of the introduction of chapter 2A, is filing of DRHP with the existence of convertible securities. So you see, in a lot of unlisted companies, there are existing investors, existing PE funds, VC funds who have invested in the company, and most of those funds and investors are holding securities, holding convertible securities in the company. They are not holding equity shares. So in the existing framework, there is a eligibility criteria under Regulation 5 of ICDR, which states that before filing of DRHP, those convertible securities shall be converted into equity share, which means you have to mandatorily give a right to those investors in your company. And even your IPO, if not succeeded, then also they are holding shares in your company. Or maybe if you do not proceed with the open offer, then also they are holding equity shares in the existing framework. Now, in the alternative framework, what SEBI has amended is that you can hold your convertible securities that has to be converted into equity share only prior to the issuance of SEBI approval. Like while filing the DRHP, pre-filing of DRHP, you need not to convert those equity shares, those convertible securities into equity shares, and you can test the waters, you can get a validation on the valuation, you can get preliminary approval from the SEBI that how they are moving ahead, whether there are any legal challenges or not, and thereafter you can convert the securities. That would be the last stage. You will intimate it to SEBI, and then they will issue their final observation letter. So this is also a very significant and good amendment by SEBI, which will help the industry. Apart from it, they have, which I was mentioning earlier also, that they have earlier in the existing framework, the marketing and publicity can be done from the date of filing of DRHP, but in the alternative framework, the general marketing and publicity is not allowed. Only limited marketing with qualified institutional buyers is allowed, where you can test the waters and you can get the valuation, get the validation on your valuation. So this is also a significant and important amendment in the new framework. Now, interestingly, we are hosting our webinar on 2nd of December, and I have got a news of yesterday that Tata Play has become the first company to file confidential papers with SEBI, and they have filed it on 29th of November. And it seems that the changes SEBI has suggested will help the industry to do so, and more of IPOs will be done in this process only. Obviously, by introducing this pre-filing process, the overall process for getting SEBI approval has been extended by some 30 to 45 days. But yes, the purpose is not getting defeated here. Your information is not going on public, and you just have to make an announcement on public domain that we have pre-filed the DRHP. So the amendments are welcoming, they are good, and I think it will benefit the industry. That is all from my side. Thank you. Sir, I can't hear you. You mute.
Thank you very much, Ruchika, for taking us through very significant changes which have been made in ICDR. And hopefully, Manoj, will you like to add something to what Ruchika has said? What will be the market section and
Sir, a few very important aspects, like Ruchika has already said, many of the companies have this concern that the offer document would disclose all the detail in public domain, including competitors, and which if the IPO is not coming in within a reasonable time, then it becomes disclosure without any benefit. So they don't want to do this. So this aspect is very important. Another aspect is the companies in which there are investors. In many of the cases, they take convertible instruments with a valuation linked to a future event, and they continue till filing of DRHP. So at the time of filing of DRHP, it is mandatory that all convertible instrument must be converted and converted into equity before filing of the DRHP. Whereas this restriction has been removed in case of pre-filing. So let's say in one case, one startup has filed DRHP and they have converted all the pending convertible CCDs, CCPS, all that, and then filed with SEBI. And later on, they could not come out with the IPO. So the right of the investors, foreign investors or private equity investors would get freezed there without getting exit in the offer for sale. Whereas in this case, if the pre-filing clearance is not coming, they will continue to hold convertible instrument and they may look into other aspects of getting exit from the company without diluting their right to, let's say, in case of CCDs, they continue to get the coupons, or they would have right to convert at a fair value at a later date. So those benefits will continue till actual filing of the offer document. So, and that is one of the very big relief to investors. So I think this will be a very welcome move from the SEBI, and it is a well-established practice worldwide. So it will give benefits, and many of the cases would be filed. It is Tata Play is one of the case.
Thank you, Manoj.
Yes.
Now we come to the questions. I think the speakers have made such a good exposition of the subjects that there are not many questions. However, whatever few questions I have received so far, I will take up. Mohini, there is a question for you. Mohini?
Yes, sir.
Is there any expected, what is the relevancy of mandatory disclosure of educational institutions and past employers by the designated officers of mutual fund? Is it not illogical to impose such a condition?
In the insider trading cases, the persons who are found guilty of these insider trading cases, in that case, because they will be trading based upon some information. And we all are aware of that the information originate in the organization first. So to track and to create a chain, that the SEBI faced challenge that from where that person has received that information, because they're not directly the employees of those organizations. So in that case, how they will be tracing that they might have some connection with the persons who are working in the organization. So to establish and to find that thing, so they have asked the designated persons of the organizations that they give their educational institutions details and the details of the organizations where they have been employed previous to this organization, because they have the connections in those organizations, and they have friends in the friends with those colleges where they have graduated. So if to establish that connection, they have asked this thing. So otherwise there is no per se other thing, because they want to establish the relationship between the persons found in that and the persons in the organization. This is the only reason.
Thank you. Manoj, there is a question on IBC.
Okay.
Is there any expectation to reduce the threshold limit of rupees 1 crore prescribed under IBC during COVID period?
I don't think that is going to reduce. Government is very much clear that this the earlier limit was very low, and many of the cases were coming which were not very much actual case of insolvency. They were defaults or disputes, mainly operational creditors delays and disputes. So IBC is not a recovery tool. And government does not want to promote it as a recovery tool. They want serious insolvency cases to be resolved through it. Burden of cases in NCLT is already very high, which will take a lot of time. 14 days mandatory period is not getting met in almost every cases. So the burden cannot be extended further by bringing this down to, let's say, 10 lakh rupees or 1 lakh rupees as earlier. it will again flood the NCLTs with many of the operational creator cases, which mostly get settled outside as a recovery tool. So government is not at all interested to make it as a recovery tool, and it will not reduce.
Okay. Thank you, Manoj. And I may supplement that in the coming session of Parliament, we may expect a very major overhaul of the entire
IBC.
The entire
Yes.
code. And
Yes.
so let us hope and see what comes.
Right.
Mohini, there is another question for you. Can you give us the list of policies to be made by mutual funds? What are the policies they should make?
So first is code of conduct. They need to frame, then they have to frame a policy with respect to their internal, strengthening the internal control systems with respect to the trading as well as the information sharing. The next is whistleblower policy, leak of UPSI, and informant mechanism as well. So all these basic policies they need to prepare.
Mohini, again, how should mutual funds go about in creating and maintaining structured database?
So there are many tools in the market. We also have one tool by the name of Insolvency. So in that, generally the application captures the information about all the designated persons. So their basic info get captured, with whom they are the information are being shared, like the persons who are working on the fiduciary nature of business with the organizations, like auditors are there. Other dealers are there, so they have to, if they're sharing the information, they have to obtain few information like the PAN number and the confidentiality agreement and the person with whom they are dealing in that organization. So those details also need to be obtained and then to be captured in the structured database. So application provide this provision as well. And same, then the person, whenever there any UPSI event in the organization with respect to any scheme is, so they have to create that kind of event and in that this structured digital database, and the persons who are the designated persons, and if they are sharing the information with respect to this, so they have to maintain that thing. So in this manner they can go and purchase the tool and this application, and they can start maintaining their SDK.
Thank you. There are few more queries. Again, Mohini, say, is AIF2 required to maintain risk management policy, outsourcing and investment policy?
I think I'm not the right person to guide on this. Either Manoj or Anjali ma'am, they can guide on this. AIF, which kind of policies the AIFs have to maintain?
I don't. I think Anjali ma'am, she can help you in that.
Anjali, are you there?
Hello.
Anjali, there's
Yes, sir.
you.
Hello.
Is AIF required to maintain risk management policy, outsourcing and investment policy?
Risk management policy is needed to be maintained. Outsourcing policy, there has been some amendment recently, so I'll have to check whether what's the present law. Risk management policy for sure is needed to be maintained.
Investment policy?
Investment policy is also required. Yes.
Thank you, Anjali. And with this, I think any suggestions from any of the learned faculty? Because we are through with the questions.
So in addition, one thing that I think we must discuss with our participants that in addition to the amendments which have been promulgated, there are two discussion papers, important discussion papers, which have been issued by SEBI. One is on the materiality of events with regard to Regulation 30 of listing regulations. The last date for the same was 27th of November, but SEBI has today only extended the date to 12th of December. So I think we, being listed companies, being the most affected people by any of the amendments, we should give our suggestions to SEBI. Likewise, the other discussion paper which is there is changes in the buyback regulations. For the same, the last date was yesterday. I'm not too sure whether it has been extended or not, but last date otherwise was yesterday. So being listed companies, being the compliance officers of listed companies, it's important for us to give the suggestions on any of the discussion papers which come in. So if any of the people feel that they may get affected, they should give their suggestions.
So we invite all our participants to give their further suggestions. We already had our last webinar on the discussion paper on LODR. And if they have further suggestions, or the suggestions which we received during the webinar, we have already forwarded to SEBI. And if there are any further suggestions, and since the date has been extended, we'll be happy to forward the same to the regulator for its consideration. Friends, there being no more queries, it is my privilege once again to thank you all the participants who have attended our webinar and all the learned faculty who have taken us through the various updates during the month. And friends, our journey continues, and our next 103rd webinar will be held on Friday, 9th December from 4 p.m. to 6 p.m. And there is a very important topic on which we are holding this webinar, that is on strategic human resource restructuring. As you all know that in emerging markets, business restructuring becomes inevitable. And apart from financial, operational, and legal restructuring, human resource restructuring is very important. And our next webinar will be dedicated on discuss and deliberate on these issues, particularly relating to issues and liabilities for transfer of undertaking for mergers and acquisitions, how to plan and execute retrenchment, closure in a crisis to reduce liabilities, HR restructuring to strengthen skill sets, how to deal with the unions, how to meet the needs of business process re-engineering, and deal with manpower redundancy, if any, and how to address the technological changes in the business processes. So, all these points will be discussed, and I'm very happy to announce that Mr. Anupam Malik, the former Labour Commissioner, he is very kindly agreed to address us all on this very important topic. Thank you very much for joining, and we look forward to your participation in larger numbers. Thank you very much.